Welcome back to The Verdict. I'm your host, Tammie Smeltz. In this episode, we're catching up with two returning guests who always bring valuable insight and perspective to the conversation. Auster from the Medical Society of the State of New York and Marc Craw from MilMC's General Counsel Office. Marc and Mo spent a lot of time keeping a close eye on the legislative and regulatory issues affecting healthcare providers, so we're looking forward to getting their take on the latest developments and what they may mean for physicians across New York. Well, welcome back, you guys. I'm really excited to have you back on the podcast. I can't even remember if this is the second time, the third time, the fourth time. I feel like you guys have been on quite often. And I almost felt like I didn't need to introduce you, but because we have so many new listeners on a regular basis, we are going to do some introductions. So I will shoot it over to Mo first. Mo, can you introduce yourself and just tell our listeners a little bit about what you do with MSNY and your role there?
Well, thank you again, Tammie and the MilMC team for inviting me to do this. And yes, sometimes you can't tell if it's second or third. Feels like Groundhog Day because we feel like we talk about these same topics over and over again. But my name is Mo Auster. I'm the Senior Vice President and Chief Legislative Counsel for the Medical Society of the State of New York. I oversee all of our advocacy operations, in our Albany office activities, and both our Government Affairs Division and our Public Health Division. And I have been at the Medical Society in this December. It will be 28 years. And to put perspective on how long I've been with MSNY, my first year with MSNY was the last year the New York Knicks made it to the NBA Finals, which was 27 years. So just to put the time frame that I've been with MSNY in perspective.
Oh, that's really funny. So I'm hoping that our listeners remember, a lot of what we're going to talk about the law, but I think they're going to probably remember that more. Okay, so Marc is with one of us. Marc, can you introduce yourself, please?
Sure. Thanks very much, Tammie, and it's great to be here again with Mo and yourself. Always enjoy this podcast. My name is Marc Craw, Senior Director of Government Affairs for MilMC Insurance Company. As the title implies, a lot of my work and profile at MilMC is to handle our government affairs portfolio with the legislature, with the governor, and with other government agencies that impact MilMC and our policyholders. In addition, I do conduct a little bit of legal research as directed by the General Counsel for MilMC, who I'm within that office, giving legal advice to the various departments of MilMC.
Thanks, Marc. And as most of our listeners know, we like to have you guys on at the end of session, and you guys are, great friends and colleagues. So this conversation is going to be fun, but also interesting. So we're going to start off talking about the budget, the New York State budget, and we'll start off with Section 18, excess insurance coverage, which is something that's very important to pretty much all the physicians in New York State who may work in a hospital setting and need that extra layer of coverage. So Mo, can you fill us in about what happened during the session?
Yeah, thank you. Thanks for the question, Tammie. To begin with, this was an incredibly challenging legislative session. I mean, frankly, the denominator of possible adverse outcomes was so far greater this year than in recent memory. And I can't even count the number of times that, I had a staff person in the Assembly or Senate, the governor's office, come to me on a topic for which we were opposing. And it was just, there are so many different items we had to fight this year. But again, thankfully, working with allies such as MilMC and the hospital associations, we collectively again successfully advocated to convince the legislature to fight back against the administration's proposal that would have required the 16,000 physicians who receive excess medical liability insurance coverage to pay half the cost of that coverage, which frankly cumulatively would have been a $39 million hit to those physicians. Which is just not tenable in the amount of liability costs that physicians face right now in the high cost state. But I will say this was one of a number of different areas that we had to challenge this year in this year's state budget, and just the kind of the other issues that we had to face at the same time really made this fight all the more challenging this year because, legislators only have a certain amount of attention span you can bring to their attention. And you're talking to them about IDR or surprise billing issues, or you're talking to them about scope issues or excess. And, it kind of, you almost feel at times like it becomes kind of like a broken record and it's like the same thing over and over again. But we really can't ever take for granted that the legislature is going to reject this cut because we've seen in other areas, frankly, which we saw this year on other areas, not liability issues, but other areas of the budget impacting physicians, where there were repeat issues that had been rejected in past years, but were adopted this year, or variations were adopted this year, because the governor dug in so deeply on these issues that the legislature in the negotiating parlance really had very little wiggle room on them. So again, we can't ever take victories like this for granted. Every year is year to year. We're very glad that the legislature did reject this cut, but it does, there's every year is different.
Well, thank you for fighting so fiercely for that. I can't imagine what would happen on the year that maybe that, does not happen, and our physicians have to pay 50% of that premium. I could see them leaving the state or maybe just not practicing anymore, right? With that.
Absolutely. And when you think about what, particularly all across the state of New York, but downstate New York, you have physicians who pay hundreds of thousands of dollars in premiums, and the excess cost, they'd be adding on another $20,000, $30,000, $40,000 cost onto what they already pay. And at a time when the practice environment in New York is incredibly challenging, high overhead costs, why would a physician tolerate that when they could go to, another state, Florida, Texas, California, or some other state, which is ranked much higher for practice of medicine, and be able to make a living far better in those states than they could in New York.
Agreed. And pretty much, I mean, the physicians here in New York really need that excess layer because the verdicts are all over the place with, excess verdicts. So this is, something nice that New York does for them, and hopefully it doesn't go away. So thank you for all you do every year to fight this battle for our healthcare providers. Mark, do you have anything to add on this?
Yeah, I do want to add a little bit, and I again applaud the wonderful partnership and really great working relationship that all of Milmick has with all of the medical society of the state of New York. And in addition, Mo and I enjoy the advantage of we go way back with our working collaboration to the late 90s, even before the
Yeah,
Knicks made it in 99,
that's
but
right.
98, 97. So we go back a ways, but it's really been a terrific working relationship. It continues to be so. And I just want to say again, I really applaud how Mo and the entire medical society took the charge in opposing the governor's proposal that, for the reasons you stated, Tammie, and Mo noted as well, is just so destructive of the good public policy behind Section 18, namely to alleviate the medical liability costs for physicians and for the entire medical system in New York State. And it does serve that function. So that's why we will continue to support the medical society and all of our policyholders in advocating against any modifications to this Section 18. I would note it had one other additional proposal that would be harmful more to medical liability insurers, but it would further destabilize, I think, the Section 18 program as well. Just to note for the listeners was it also had a proposal, and Mo recognized it because we've seen it in prior years, that would restructure the actual payments to Section 18 excess insurers over 2 years. And that could lead to there are some Section 18 excess medical liability insurers with a little less favorable financial condition, let's just say. So it could make it problematic in terms of the entire Section 18 excess market and destabilize it a little bit. So that's it's not as harmful an impact on obviously cost policyholders or that provision to divide the cost by half and impose half on the physicians, but it's just another element that we were also opposing. So I want to note that we were able to defeat that as well. But again, I think we got a good result. And what I admire is that the medical society and Mo are able to focus on that as well as the myriad of other issues. Because Mo is exactly right. The medical community faces a broad host of proposals. Some are positive, one or two. It seems like many are not. So they do a wonderful job. And at Milmick, we're fortunate we can kind of focus on, the smaller bore issues that were in the budget that really impact medical liability, one of them being Section 18. So we really enjoy that partnership and working with them to achieve a positive result. But we'll have to keep fighting it, as Mo noted. So I agree there.
Thanks, Mark. I totally agree. We're going to stick with you, and we're going to talk next about the MIF, the Medical Indemnity Fund. Can you tell our listeners what transpired with that?
Certainly, Tammie, thanks very much. And just to remind the listeners a little bit, the Medical Indemnity Fund was created in 2011 out of the state budget negotiations that year by then new Governor Andrew Cuomo. And what it was meant was initially the proposal by Governor Cuomo was to actually have a cap on non-economic damages, those pain and suffering awards that people hear about, of $250,000, modeled on then California's cap. California has since expanded it, but in any event, many states do have caps, as some of the listeners may know, but New York does not. As the process was playing out in 2011, we were not able as an industry to get the caps. So as a result, the Medical Indemnity Fund was created as a way of at least alleviating some of the burden of these cases that go into the MIF, Medical Indemnity Fund, we call it MIF, which, just to remind everyone also, is anytime there's a neurologically impaired infant and a case is brought to recover damages for that infant, and either through a settlement or a jury verdict or a court award, there's found to be negligence that caused the injury that resulted in neurologically impaired infant, that in those cases, the future economic costs for that infant are now borne by essentially the state through the Medical Indemnity Fund. And so that fund has been in existence since then, and it helps alleviate on hospitals and OBGYNs almost exclusively are the groups affected. But it's an important program in that it relieves the burden of those two entities from paying the future economic damages, which can be very significant, as you can imagine, in some of these cases. So in that Milmick, we view it somewhat as it's one of the two medical liability tort reforms, I'd say, that we have. They're limited tort reforms, but obviously Section 18 is one because that helps alleviate the excess insurance costs, as we noted. And the other is the MIF for those OBGYNs and for hospitals who are hit with the future economic costs. The MIF fund pays for those. So that alleviates that as well from the defendants in those cases. So what we've seen is 2 years ago in 2024, the budget was passed. That one was relatively early, right, Mo, for what's happened lately. I think it was early May.
Would pass for early,
Yeah. So it was early May. Then a few weeks later, the Department of Health, who administers the MIF, they say, oh, we have to close the fund because by law, if the payouts by the fund and it ends up that the assets of the fund are less than 80% of the liabilities, it's a fail-safe, essentially. They say, we're sorry, we can't have new enrollees into the MIF because we just can't afford it, obviously. And instead, we have to just concentrate on funding for the current people. That obviously caused a huge kerfuffle, I guess the best way to put it, in the medical community, in the plaintiff, and in the medical malpractice New York plaintiff bar and the defense bar, obviously. And so as a result, the governor's office pretty quickly were able to give basically an emergency transfusion of cash from other areas of the budget to kind of tide it over until the following year. The next year, in 2025, they were able to fund it at a higher level. It was $211 million. This year, the governor proposed ratcheting down, I don't want to get too in the weeds, but basically the reimbursement rate for providers of those services that the MIF pays for. Her proposal was rejected by the legislature, and in the final wash, There was no modifications or changes to the MIF program itself, and they funded it at 155.5 million. But we would note that is obviously less than 211 million. So I think stay tuned on the MIF next year. That could be a very significant budget item in terms of how the legislature and the governor view possible reforms, modifications, just because it's primarily a fiscal issue, obviously. The costs keep mounting over time as more people come in, more neurological impaired infants come into the system, but there's only a finite amount of money, obviously, and you have that 80% assets to liabilities threshold. So we'll see.
Okay, thanks, Mark. We'll keep our ears and eyes open for that. Anything that transpires next year. Mo, do you have anything to add regarding the myth?
I do not. I mean, we're really appreciative of everything Milmick has done on that front because it is an important fail-safe in our healthcare system. And I really rely upon Mark to help educate me on kind of what we need to know. I know there was, for example, a bar association work group who was interested in looking at it from a variety of perspectives. It wasn't just from the plaintiff side, but also from the defense side as well too. And they reached out to me for some input, and I immediately pointed them to Mark because of Mark's involvement in it. And so that I think that would just highlights again the great partnership that Misny and Milmick have on a whole range of issues.
So Mo, we're going to stick with you, and we're going to talk about the scope of practice expansions. I know this was a hot topic with a lot of the healthcare providers. Can you fill us in about what happened?
Yeah, and I mentioned before, thanks, Tammie. And I mentioned before of the litany of issues that we were working on the budget. I talked about the surprise bill issue. There was also a workers' comp issue. And on the positive side, we also accomplished getting some prior authorization reforms, some modest changes, but some steps to reduce the number of times that a physician has to get something approved by a health insurance company. So that was a positive. But one more adverse proposal that we had to fight again in terms of things year after year was a proposal that would have enabled many physician assistants to practice independently after practicing for 8,000 hours if they practice in primary care. But primary care was defined extremely broadly and could encompass the number of different specialty areas. And we have great esteem for the work that's provided by physician assistants across the state of New York. They're an integral part of our healthcare system. We did work with the physician assistants and the chairs of the health committees a couple of years ago on expanding the services that they could provide, including a number of standing orders in hospitals. But we are very concerned about having them be removed from the physicians themselves who oversee what they do. And we think that is of concern to the public. We know in other states, that have allowed it, it's also resulted in increased in healthcare costs through additional referrals to other healthcare practitioners and additional tests. So we believe it's an important patient safety protection that we maintain physician supervision over PAs. But again, this is a proposal that every year seems to come back. It's always sort of used as one of the proposals when they talk about physician shortages across the state of New York. This proposal comes up, and we often say, well, if you're looking at like physician shortages, why not look at the reasons why physicians don't want to practice in New York State? The high cost of liability, as we mentioned before, the significant number of regulatory requirements, and the challenges getting paid by health insurance companies. Not to mention other ideas about expanding the types, expanding physicians, such as maybe allowing more international medical graduates, IMGs, to practice in New York State. There are a number of different steps that we could take to enhance physicians in New York State. Let's look to that rather than finding ways in which to expand the number of non-physicians on the public. And again, I'm not sure if we're talking yet about post-session yet, but there were also a number of other scope of practice expansions that we also had to grapple with as a session went on. Certainly we work with our specialty societies on a number of different areas, the Anesthesiology Society on raising concerns about legislation to enable independent practice for nurse anesthetists, with the psychiatrist on measures that would allow psychologists to prescribe. And then this year we had a kind of an out of the blue fight relating to a bill that literally was on the verge of passing on the final day of session, which would have greatly expanded the services that could be provided by chiropractors, which really kind of came out of the blue. But we worked very closely with the societies representing orthopedic surgery, radiology, neurology, and ultimately that legislation was not passed, but it did move through several committees. And so certainly it's something we know will be on the horizon next year. But again, I might have jumped the board a little bit and like moved on to post-budget issues, but just to keep, but we were teeing up various scope issues, so I got a little over anxious.
That's okay. Just out of curiosity, what would that entail if the scope of practice was expanded for a chiropractor? What type of services would they be able to offer?
Well, they would go beyond certainly the vertebrae to a number of soft tissue areas of a person's back. It could completely expand the number of tests and radiological tests that they could provide. And the bill was also very vague about the types of criteria that would be needed to have for these additional requirements, and leave things to the education department. And typically, when it comes to scope of practice issues, the legislature tends to want to be very specific about you can do this if you get this kind of training, and it left a lot of the particulars to the state education department, which was highly concerning for any number of different physician specialties across the state of New York.
Okay. Yeah, I hadn't heard about that. I know that the podiatric standard of care is changing soon,
Right.
right? Or maybe even already, so they can do some work on the ankle.
Yes, and but to be fair, and we certainly had concerns with that, but that was the end product of multiple years of negotiations between the orthopedic community and the podiatrist over possible standards about revolving around ankle surgery privileges. And this chiropractic bill had none of that. It was like all of a sudden it was amended in the assembly. It was put on an assembly higher education committee agenda. There was no negotiation with any of the orthopedists or the other specialty societies that typically are involved when the legislature decides to do a scope of practice expansion. So that was really particularly problematic because, again, usually there is some element of a back and forth between the non-physician group and the affected specialty before the legislature approves this. But again, this was grease to go. And thankfully, the chair of the Senate Higher Education Committee, on the last day of session when this was beginning to move, really pushed back strongly against it because she didn't believe this was time or had enough vetting for this to go forward.
Makes sense. Makes sense. And I know earlier you talked about CRNAs practicing independently. I'm just going to pick your brain on this, and it's totally off topic. And Mark and I briefly talked about this, but have you heard anything about anesthesia assistants? We recently
Mhm.
learned that there might be a program coming to Buffalo, actually,
Yeah.
where you are not even a nurse. You just have an undergraduate degree in some like health related field, like biology or some science field. And then it's a 2-year program, and you can kind of act like a CRNA, but not be a CRNA. Have you heard that?
Yes, and there was a resolution which was advanced to our Misni's House of Delegates a couple years ago when we actually passed a resolution, a policy that called for Misni to support those kinds of arrangements. Because again, in those circumstances, they are acting under the supervision of an anesthesiologist.
Good, perfect. It was news to us, so I thought that you would definitely have the scoop on it. So thanks for that. We're going to go back to Mark because we're trying to be even here between Mark and Mo, and we're going to talk about judgment interest rate reduction proposed by the governor. Can we talk about that for a little bit?
Sure, Tammy, I can talk about that, then segue into post-budget as Mo did, and I liked how he did that. That was a good way to pivot. The 9% judgment interest rate that is in current New York law is obviously extremely high. That's been around since 1980 when interest rates were at 18%. You couldn't get a mortgage very easily, et cetera, et cetera. So flash forward, I know interest rates have come up a little bit in recent years, but they're still below 9%, obviously. 26 sister states, the last I checked, they have a judgment interest rate, which is essentially, as it sounds like, it's just an interest rate that accrues after a injured person who wins a medical malpractice suit the amount of their judgment, you then tack on a judgment interest rate, which is 9% in New York. Most states use the federal prevailing market rate, which is usually like 4 or 5%. So obviously lower. And there's really no need for it because really it's inflating the money that ultimately the plaintiff attorney will receive, in that sense, because they get it on the entire amount of the judgment, including interest. So we've lobbied for years with Misny and others to reduce this. The last couple of years, the governor has actually, and it started under Governor Cuomo, and Hochul has continued it, put in the budget to reduce that judgment interest rate to the prevailing federal rate that's calculated on a weekly basis. We obviously support it. Unfortunately, the plaintiff bar, the New York Trial Lawyers Association, they have been very firm in opposing it, and the legislature has gone along with them. So we will continue the fight, and I'd love to see that change because I think that would make a real impact, albeit not large, but on the overall high cost of medical liability that physicians and members of MISNY and others have to pay. So we're continuing to support that. But that was once again taken out of the budget in the final budget, so it wasn't there. But hope springs eternal.
And when does that interest rate start? Does it start from the
It
initiation of the
starts from the
lawsuit?
time of the judgment is entered. It does
Okay.
not start from the date of injury. That's a great
Okay.
question because some states, in fact, many do have pre-judgment interest, it's called. So you're injured due to a negligence surgery in 2024, but you don't get your award till 2025. In some states, it starts running at that date of surgery, 2024, continuing. That's a lot of money, as you can imagine, especially medical malpractice cases. New York were the longest to resolve them in the nation, and we go 5, 7, 8 year. You know well, Tammie, how many years it takes often in New York to resolve a medical liability case, even if it gets settled or otherwise disposed of. So for that reason, it could be quite costly if we ever had prejudgment interest. We've beaten it back. There have been only a couple bills. Recently, it hasn't gotten a lot of traction, but it's always something we're watching for. So right now, we'd love to see, though, in addition to keeping, the post-judgment interest, clock, that we see a lowering of the interest rate would be very helpful for helping to reduce medical liability costs. And then also we're pivoting, and we had to do that this year after the budget. There were a couple of bills that would expand liability on our healthcare providers and healthcare system and hospitals and other facilities. And I can briefly go through those and explain them. But I want to start out with some pretty amazing news. As everyone probably remembers, we fought the Grieving Families Act, urged a veto. The governor's vetoed it the last 4 years. This year, I think due somewhat, and I'd love to hear Mo's thoughts, there was a Donnybrook in the governor's budget over liability, but it was auto liability. It was not at all medical liability. But what that did was the plaintiff bar was really on their back foot, really fighting it hard because many of our listeners may have heard stories, especially downstate, of massive fraud, stage crashes, and then people, bilking the system essentially for money, fraudulently. So that fight ended with some of the auto liability laws curtailed, their past expansive nature. So an actual win. And candidly, I'd love to see maybe we can parlay that in future years. We'll see how that goes. But there was a true crisis at that moment that people could acutely put their hands on. People knew these staged accidents. Everybody has auto insurance in the state of New York, pretty much, so it was a very good affordability issue, obviously, for the governor. So she essentially won. She didn't get all her proposals, but got a fair amount. But that ended on May 28th with the adoption of the budget. And then we ended a week later. Literally, the legislature ended on June 5th. So I think part of it was they both were spent from the fight and the lack of time to really allow for full debate, which these bills usually, do occur, because Mo and I work very hard to get the legislative opponents of these measures up to speed and say, this is what you really need to look at and ask questions on, and they often do. So as a result, the Grieving Families Act, this year's bill, did not even move. Another bill that would have expanded liability was a new one. It would have moved the medical malpractice statute of limitations, which, this is like almost a replay of Laverne's law, especially in the early 2010s, the more expansive Laverne's law. It would have basically gone from the current date of omission for an alleged medical negligent act or omission to the time of the plaintiff reasonably knew or should have known of the injury with an outer limit of 7 years. So it's basically date of discovery of their alleged negligent injury. So obviously that would blow up the statute of limitations. You have a lot more cases, so that's a very bad bill. It also had 18 other discrete anti-defendant provisions. I mean, it was a horrible bill. Fortunately, I think it was so horrible, even the legislative sponsors in the Senate and Assembly understood that it had some real significant issues and it did not advance. But we're prepared for that. And next year, we'll see if that comes out in a new form because all bills have to come out in a new form next year. Then finally, the third bill I'd mention, and this bill would be very damaging to medical liability and increase costs greatly. Right now, if there's any verdict, an award of damages in a medical malpractice case, as well as all other personal injury cases in New York, the defendant can appeal that verdict and decision and say the damage award was too high or too low, but usually it's too high because it deviates materially from what's reasonable compensation for a similar case, those facts and circumstances. Well, by its very nature, that is a somewhat better objective standard, and it was adopted in 1985 as well as Section 18 as measures to reduce medical liability and cabin in kind of reduce the damages. So flash forward, this bill says no, jury awards should be sacrosanct. You should defer, the court should defer to them almost totally unless it shocks the conscience, which is an incredibly loose, incredibly subjective standard. Even if the judges try to do a good job, that's just something that's asking for awards to be upheld that, are not do deviate materially from what's reasonable. So we would argue against that. Fortunately, that bill also did not move. And as I said, essentially none of the liability expanding bills that in past years we see at least one or two, right, Mo? Saw none this year.
Yeah, no, and again, I don't not want to underplay at all the fact that there was no Grieving Families Act to ask for a veto this year because the last several years, and again, great credit to the governor for her continued veto of that bill. It's been a great team effort between Misny and Milmick and the hospitals and the business community and the municipalities about convincing the governor about the impact, but frankly, also kind of subtly also convincing the legislature to not attempt to override the veto, it's kind of an interesting dynamic. We almost sort of take it for granted, but they do have the power theoretically to override a veto.
Yep.
And I think maybe they just were not, whatever it was, they did not think it was a good use of their time this year to pass the same bill again and go through the whole process where there's a veto. But I do think it is the result of the multiple year effort partnership. Again, obviously our respective organizations, but I give great credit to the physicians across the state of New York who have been relentless in contacting the governor and writing op-eds and educating the local community about the impact of it. Because when you take a step back and think about it, it is something that is it's a tough argument to make. And you have to be very careful about how you present your argument about the impact upon society at large, about what it means for healthcare, because it is a very sympathetic point to make that when somebody might be younger or older and may not have the earning power, they can't get as big of a recovery in a negligent situation. So really, we have to continue to make that point over and over again about how damaging this bill would be on society at large, and not take it for granted. Because again, we could be dealing with this again next year, but at least for this year, we don't have to deal with that specific issue.
Great. Mo, do we have anything else to talk about post-budget wise?
Well, I mean, there's a lot of other items that we had to grapple with throughout the month of April and May, and thankfully none of them passed, but there were any number of physician practice mandates that, again, not necessarily on the liability front, although potentially there could be a spillover on the liability area. But all these proposals which would have created new requirements when a physician prescribes an opioid medication, or required medical record segmentation for care provided relative to reproductive health care or gender affirming care, which would have required physicians to basically maintain multiple electronic health record systems, or proposals that would have required CME for any number of areas, and which frankly did have a lot of interest. And we're moving in one committee or another in one of the houses that we really had to spend a lot of time on. That frankly, because of the constriction of the legislative cycle this year, where the budget finished a week before the session did, many things couldn't come up, but at the same time, many of these adverse items that were outside the budget were being talked about. And when I talk about earlier about trying to get legislators' attention, and we can't talk about 6 items with a legislator, saying, stop the excess cuts and don't pass, Grieving Families Act. And oh, by the way, don't pass this. So you have to pick and choose, because when you're a lot of times you're trying to grab someone as they're going into session, like a key chairperson of the health or insurance committee, you have time to talk about one thing, and you got to have that elevator talk down about the top issue, because you're not going to have time to talk about 7 or 8. So that when I talk about the denominator being really big this year, it really, the practical impact is the ability to actually convince people about why you think a particular bill is a bad idea. And frankly, that is going to become more challenging even next year when you look at the not only the election results, but the number of legislators who are retiring. There's going to be 30 new members of the Assembly and Senate next year, and a whole new bunch of people to actually educate about our issues. And one thing I have found over the years is that issues that we advocate on, really you have to overcome a strong presumption on the other side of the issue, because people really do care about healthcare, and they come into these with the best of intentions, and you have to highlight why this is going to be adverse for physician practice. The same way in the Grieving Families Act, why even though there's a sympathetic set of facts that lead to wanting to advance this bill in the first place, there's a counter argument that's a little more subtle, but is incredibly important about the impact on society. And that's a whole new cohort of legislators we're going to have to make sure are more familiar with these concerns.
I think we're going to have to recruit another person.
Yeah.
It sounds like you're going to have your hands full next year, the two of you.
Yes. It's an interesting dynamic too. And again, I don't want to belabor it. You could probably edit this out later on. But again, Governor Hochul is likely to win based upon the the polling as it exists right now, June 29th as we're recording this. But who knows what happens? And there's kind of been an interesting stasis between the governor and the legislature. Even though you have your fights, there's generally been somewhat of a collaborative relationship between the two. And the legislature really does not take up vetoes of bills vetoes of bills. The bills have been vetoed by the governor that passed the legislature. But if for some reason Bruce Blakeman were to be elected, that dynamic goes completely out the window. And I don't think that's what's going to happen as of what's right now, but it is something to ponder as we head into the next year.
Agreed. Great point. Well,
good point. Yes. But I feel like we need to end on a positive tone.
Well, this is what we do. We kind of think through, we applaud ourselves for everything we got past, everything we were able to defeat. We take a couple weeks to like take a deep breath, pat ourselves in the back, and then we begin to like get paranoid about every bad thing that can happen next year.
That's right.
All right. Well, let's just celebrate our wins now for the summer. We'll worry about next year.
Yeah.
Well, thank you guys for coming back on. I really enjoy. I have always said I love the dynamic between the two of you. It's fun, it's light, it's so informative, and I'm really grateful to be able to spend time with you. And have
Jason Bateman and Sean Hayes and Will Arnett have that podcast, Smartless. I think with Mark and I's hairline, we can call it hairless.
I love it, Mo. That's great. And getting even less hair, I tell you. Time goes on.
It's so funny. Okay, you guys. Well, enjoy the rest of the summer, and we'll have you back soon.
Okay.
Thanks very much. Thanks, Paul.
Guys. And that wraps up this episode of The Verdict. A special thank you to Mo Auster of MSNY and Marc Craw from MILMIC's General Counsel's Office for joining us and sharing their insights. If you'd like to learn more about MSNY and the work they're doing on behalf of physicians across New York, visit their website at mssny.org. Thanks for listening, and be sure to subscribe to The Verdict for more conversations on issues shaping healthcare today. Until next time, I'm Tammie Smeltz. Take care. This podcast is for general purposes only and should not be construed as medical or legal advice. This podcast is not comprehensive and does not cover all possible factual circumstances. Because the facts applicable to your situation may vary, or the laws applicable in your jurisdiction may differ, please contact your attorney or other professional advisors for any questions related to legal, medical, dental, or professional obligations, the applicable state or federal laws, or other professional questions.